Okay, good afternoon, everyone. We're here in Council Chambers for a special meeting focused specifically on AMPS. And AMPS, again, is the Administrative Monetary Penalties System, AMPS. This is an alternative to the provincial offenses system, and certainly AMPS is something that many municipalities, including ones within the United Counties and just to the east and west and north and south of us, have adopted. So we're very grateful to have an opportunity this afternoon through this special meeting of council to get a more fulsome briefing on where we sit. Council colleagues, you may remember that we've already had some discussion at the council table regarding AMPS, but our clerk, Ms. Preston, felt that it was most productive that we do a special meeting just because of the level of detail and the amount of discussion that may be involved. And of course, just to remind you, it is the Administrative Monetary Penalty System, AMPS, and I'm heartened to see that we may be moving in this direction. So with that, I will call the meeting to order, and I'll invite a council colleague to read our land acknowledgement, please. Thank you, Deputy Mayor.
Thank you, Madam Mayor. The municipality of North Grenville acknowledges that the municipality operates on the territory of the Anishinaabe. We recognize all First Nations, Métis, and Inuit peoples who now call North Grenville their home. We respect and support the need for cultivating a strong relationship, and we commit to Indigenous-informed decision-making to foster the path towards reconciliation.
Great, thank you. We'll now go to the approval of the agenda. As mentioned, colleagues, this meeting is specifically focused on AMPS and AMPS only, so we're looking for a mover and a seconder for the adoption of the agenda on November 18th. Thank you, Councillors O'Sullivan and Deputy Mayor. Thank you. I'll call the vote. All in favor, please. Good, that carries. Disclosures of interest. This is in regards to any financial benefit or loss arising from this evening's meeting. Are there any disclosures? All right, excellent. So we'll move on. Quite simply, we're now going to hear, I think, primarily from our planning and development staff. Ms. Preston, are you introing this session, or we're going straight to Mr. Baribeau? Also here with us, obviously, is Ms. Martin and Santerre McKenna, who supports the clerk's office. So I'll then invite Mr. Baribeau to start us off.
Thank you, Madam Mayor. I have the pleasure to present several bylaws today in regards to AMPS. If we can move to the next slide, please. The background in relation to this is back on June 19th, Council directed staff to develop an AMPS bylaw and to bring it back, and that's why we're here today. To support this, staff engaged a consultant to draft the AMPS bylaw and update several existing bylaws for integration into the new system. And on September 11th, as you remember, the new parking bylaw was brought forward and also included all the necessary provisions for AMPS at that time. The AMPS, the parking bylaw, and other bylaws presented today would officially come into effect on January 2nd, 2025. You'll see before you on the screen the designated bylaws that will be included in AMPS if approved today, with others to follow at a different time or date. You'll see that the parking bylaw is also illicit, but previously enacted on September 11th. Care of roads bylaw, the fence bylaw, noise bylaw, parks bylaw, the sewer use bylaw, a new smoking and vaping bylaw, yard maintenance bylaw, animal care and control bylaw, and the property standards bylaw. Now, in regards to AMPS, there's a framework and how a ticket is issued through the whole process to having a ticket affirmed if ever appealed by an individual. If there's a violation, a bylaw officer would issue a penalty notice, also known as a ticket, but formally as a penalty notice. It could be issued upon a vehicle for parking-related matters or upon a person. It could also be sent by mail. It could also be delivered to the person in control of the vehicle. For non-parking matters, it could be delivered personally or by mail as well. The recipient of the penalty notice has several options available to them. They can pay the ticket or the penalty notice within 30 days, or they can request to have the matter reviewed by a screening officer. The website of the municipality and other, they could come in person as well, but they can ask for that request to review by a screening officer. and which at that time they would be given a date to attend and meet with staff. The screening officer, which is municipal staff, which one of the bylaws today is brought forward, will list 3 different individuals. They will look at the matter and decide to either affirm the penalty notice, cancel the penalty notice, reduce the amount, and or provide additional time to pay. Now, the individual who receives that decision from the screening officer can make a decision to either pay that penalty at that time, or they can request for the matter to be brought to a hearing officer. The hearing officer this whole process would be more of a formal setting, similar to a court system, but not as formal. And that would have to be done within 30 days of the decision by a screening officer. The individual who is also debating on bringing the matter forward or having it brought to a hearing officer can decide for a request for additional time. So if they want to, consult with potentially a lawyer, they can make a request to have an additional 30 days to review the matter to decide if they want to have a hearing. Now, if they decide to have a hearing, staff will give them a notice for the hearing date, it has to be a minimum of 30 days. Upon review, at the time of the actual hearing, the hearing officer will hear both sides, both from the bylaw side of things and also from the defendant, and they will decide on the process and then on the matter and decide to either affirm, cancel, or reduce the penalty. And they could also provide additional time to pay if required. The payment of the penalty. It is due within 30 days of the issuance. It can be made online, in person, or they can send a check or money by mail. If there's non-payments, so for individuals who do not wish to pay and they do not wish to contest, additional fees are applied. That is listed in Schedule D of the bylaw. And if applicable, the outstanding amount will be added to the property roll for collection in the same manner as property taxes. If the amount cannot be added to the property roll, the file will be forwarded to a collection agency for recovery. In the AMPS bylaw, Schedule A is specifically for parking bylaw, parking offenses. It lists the wordings and the amounts. The penalty amounts have increased slightly since from the current bylaw, which has been in existence for 12 years. But despite the increase, the amounts remain comparable to those imposed by neighboring municipalities. Schedule B designates the penalty amounts for the other designated bylaws included in AMPS. And these are, for example, the fence bylaw, property standards bylaw. And it also includes the wordings and the penalty amounts, but it also has an escalating fine amount. And you'll see, for an example, the first fine, so if the first person or the first time that a contravention occurs, they could receive a $100 fine. And the second time around, if they still don't receive compliance or they commit the same offense again, they could receive an increased amount of $200 or as listed in the bylaw. Schedule D lists the additional fees that are applied to a penalty notice when applicable. You'll see here that there's a screening non-appearance fee, a hearing non-appearance fee, and the amounts. That is for someone who has requested a screening or hearing and does not show up. There are late payment fees for both parking and non-parking matters. MTO search fee, those are for matters where we have to request a driver's license, the plate, to find out the owner of a vehicle. There's a cost associated to that, and that's why there's a fee showing here. There's a plate denial fee, so if, for example, if the individual doesn't pay the parking ticket, to achieve compliance, we can request from the MTO to deny their plate next time around. So it helps with compliance, and that's why that fee, because there is a cost to that as well. There's a collections fee of 15% of the total penalty amount, as most collection agencies charge 15%, some up to 30%.
Might I just intervene there?
Of course.
So the collections, you're suggesting the use of an outside collections agency?
Correct. Whenever staff here can't achieve compliance, can't receive those funds, we have the option as a municipality to send it to a collection agency to help.
Didn't I hear you just say that you would add it to their property taxes?
In some cases, you can't.
Oh, I see.
And so in those cases, you can't. You can hire a consultant or a collection agency to help you out.
Understood. Okay. Keep going.
And then, of course, there's also the service by mail fee, an adjournment fee. If there's some individual comes in and keeps asking to adjourn their matter, there's an additional fee to help move the things along to have compliance. So it doesn't prolong too long, just like the current issue in court. And then there's a property search fee of $40. There's also fees associated to that every time we do a search on the system to find out the official owner of a property, and that's to help recover those costs. And then also Schedule D lists additional ASE fees, which has to do with the automated speed enforcement. These fees are designated as part of legislation, and those are the fees showing for here. For example, the late payment fee is $20, and we cannot change that if AMPS is going to be implemented with ASE at a future date. To help with the education and public interaction in regards to AMPS, the website will have a dedicated page for AMPS. It will thoroughly explain the system, and it will guide people through the process, including payment options and hearing requests and date extensions. And people who do not have a computer or prefer in-person interaction will be able to attend the municipality for assistance as well. When you're implementing an AMPS system, there is regulations that designates that the municipality must have certain policies in place. And those policies include political interference, conflict of interest, financial management, and public complaints. Additionally, staff recommend a policy on undue hardship to help guide the screening and hearing officers when reviewing matters. In regards to political interference, the policy brought forward today prohibits any person from attempting to influence or interfere with any municipal employee or person involved in the AMPS administration, whether financially, politically, or otherwise. The policy includes reporting procedures. In regards to the conflict of interest policy, the policy identifies who cannot be a screening or hearing officer, defines what is considered a conflict of interest, provides guidelines for the screening and hearing officers, and identifies the procedures for assigning an alternate screening or hearing officer. The financial...
Can I ask about the hearing officers? Because it's not evident to me, and I apologize for interrupting you, but it's so much information. I think there may be some value in council colleagues asking some pressing questions now versus later, because it's obviously a lot of information. So if you don't mind, it's not evident to me, you're saying screening officers would be municipal staff.
Correct.
So, and the screening officers are adjudicating the matter in terms of if someone comes in and believes they were incorrectly fined, the screening officer is the first level of interaction in regards to a fine that has been issued?
To you, Madam Mayor. Correct. So first of all, the individual might come in or go on the website and request a screening officer, but they may interact with front staff prior to, potentially.
But the frontline staff would not be the screening officer
Correct.
themselves? Okay.
Yes.
So I'm just curious, we're a small community, we're a small municipality, relatively speaking. Is that typically the model that your screening officers are municipal staff?
Correct, yes.
And are they in this, how would they be selected? Are they within the bylaw department themselves, or do they, I presume they have to be distanced from the staff that have issued the ticket, is that right?
To you, Madam Mayor, that's correct. The policy actually states that a screening officer cannot be a bylaw officer.
Right.
And so when we chose, or we looked around and canvassed, we looked at some individuals who would be best suited for the position, maybe have a legislative background as well to help streamline that and to deal with those type of requests.
So then, what is the selection process for a screening officer?
So technically, the policy does, to you, Madam Mayor, technically the policy does not specify specifically the process for choosing a individual.
Okay, so we're not there yet. I'm just, obviously, I think I'm just talking out loud. If a staff person, right, knows another staff person very well, and they are, right, by virtue of having worked together on a number of files, or they have a shared work experience, but not necessarily through bylaw, because I understand bylaw officers cannot be screening officers. I'm just curious to know, like, how do we ensure objectivity, right? Because obviously, a screening officer might be in an uncomfortable position to know if they should, right? I don't know, can a screening officer withdraw a ticket or just reduce a ticket? They have all those options at their disposal?
To you, Madam Mayor, that's why we have policies, and we're going to have training as well offered.
I see, right.
Correct, so they will have those powers depending on the circumstances. If they decide, now normally the undue hardship policy, when to cancel a ticket kind of helps them decide on that matter as well. They're made to look at the totality of it and to decide if there's an error in issuance. And if there's an undue hardship claim, they can look at that to decide if a matter should be reduced, additional time to pay, and the policy and or training provided will help with that process.
And is it a confidential process? The conversation with the screening officer?
The conversation will be, it will be a meeting between the screening officer and the defendant, yes, correct.
Okay. And then if the screening officer thought that they needed more information, do they go back to the bylaw officer, or is it kept fairly separate in terms of their deliberations?
To you, Madam Mayor. So technically what happens is the bylaw officer will provide like a package
Yes.
to the screening officer, and the screening officer will review that and hear the case upon from the defendant or the vehicle owner perhaps, and they will decide based on the totality if there's an error in issuance. If not, is there undue hardship, or what's where is the defendant coming from? And from that, based on training, experience, policy, they can decide on how they want to proceed.
Okay. And I believe Ms. Preston has something to add.
Yes, through you, Madam Mayor, just for reference, one of the attached bylaws that's for consideration this evening is the appointment of 3 screening officers and a hearing officer. When we looked at staff, as Manager Baribeau determined, we looked at the staff that may already have some of this criteria or this confidentiality reporting mechanisms within their job description. We've identified 3 clerk staff that would act in this regard separate from bylaw, so that there is distance between the matters. The clerk staff also has the relevant experience with regards to reportability, keeping records and confidentiality of matters. Furthermore, because clerk staff already are heavily involved in legislative components like the Elections Act and different regards in that matter, we felt it was appropriate for this to be a relationship that existed within the municipality. And then Director Baribeau can speak more specifically to the hearing officer, but in that mechanism, most of the hearing officers that we had investigated in our deliberations and research was a third party, either a contract via a solicitor or a retiree or things like that, very separate from the municipality, so not internal staff.
So what I'm hearing is there's already a proposal on the table to utilize staff in the clerk's office as hearing officers. Okay. And that makes sense to me. So I can get my head around that, because obviously if they come in with a certain predisposition and understanding of the complexity of some of these matters from a judicial perspective, perhaps they would be well equipped and wouldn't need as much training or what have you. It's new to me, so I'm learning alongside you. Thank you. Council, is there anything else? I know I jumped in, but I just wanted to make sure that we weren't waiting until the end because there's such a high volume of information. So I'm going to recognize Deputy Mayor and Councillor Sullivan.
This may still be coming in the presentation, but I have questions about the implementation of the policy. I can ask them now or at the end of the presentation.
Why don't you ask them now, and if Mr. Baribeau is
Okay.
going to present them, he'll let you know that.
All right. I notice from the many appendices or appendi or whatever that there is a bylaw about front and side yard parking. I'm just wondering how that's, not how the bylaw is going to be implemented, but, well, I think it would come as a shock for a lot of people in the municipality that it's prohibited to park in your front and side lot. I don't know how many times you've had to deal with that particular bylaw, but I'm hoping that as part of this program, we can institute like a warning ticket system for some of these bylaws that might, the general public might not be aware of, and that there's like a comprehensive communications effort going into the adoption of this AMPS bylaw.
Yeah, through you, Madam Mayor. The parking bylaw was enacted on September 11th, and that included provisions for the front and side yard parking. It is my intention, or the bylaw service's intention, to have a transitional period, and we also have a motion before here we can provide as well. But it's mostly to provide an education to residents who are not familiar with that, on how to rectify the situation. So they may have to park on the road instead. They may have to move their vehicles on their driveway a little differently. But that has been thought of, and there will be an educational period where warnings will be issued or letters just to explain the changes.
Just to follow up, do we issue many tickets for front and side yard?
Well, the bylaw, through you, Madam Mayor, the bylaw was enacted on September 11th, but does not come into effect till January 2nd. So there hasn't been any.
Just before I recognize Councillor Sullivan and Councillor Wilson, I did want to note, Deputy Mayor, that in conversation with the clerk, there is a proposed grace period here in terms of side and front yard parking that we could consider. Of course, it's at council's discretion whether or not we want to include or continue to include side and front yard parking in the AMPS system, right? I guess we're not compelled to necessarily. There's an opportunity to reflect on that. My, I guess, a quick additional question, and then I'll recognize my colleagues, is I think when we had this discussion previously, we understood that it was a complaints-driven system. Does AMPS continue to be a complaints-driven system? Because to Deputy Mayor's point, I think there's a lot of people who for decades may have parked on a side or a side yard. They may have no idea that they would be out of compliance. They may have no immediate alternative. And I'm curious to know, how would a ticket materialize? Is it because a neighbor has complained, or because a bylaw officer drove by and noticed they were out of compliance? I think, how would that work?
To you, Madam Mayor, in the past, we've received complaints on this specific topic. In the past, we could only deal with it as a zoning matter, which it's a little bit more difficult to get compliance with. It's a lengthy process, and that is why other municipalities have brought forward these bylaws to deal with front, rear, and side parking. Yes, most of the time it would be a complaint driven, where bylaw would respond to, correct. Now, when bylaw officers do go around, they do sometimes see other violations, but in most cases would be complaint driven, correct.
Okay, I apologize for jumping in there. We can certainly return to that, but I'll just recognize council colleagues, Councillor O'Sullivan and then Councillor Wilson.
Thank you, Madam Mayor, through you to Mr. Baribeau, or perhaps to the clerk. I just wanted to clarify, screening officers and hearing officers are chosen subjectively by the bylaw department, and they are from the clerk's office? Is that right, both screening and hearing officers? I thought I heard you say something about hearing officers being third party, but then I also heard that it was hearing officers from the clerk's office.
We will have Ms. Preston answer. Go ahead.
Okay.
Absolutely, through you, Madam Mayor. So we have proposed 3 clerk staff in the draft bylaw for screening officers. So that includes Deputy Clerk Mary Remig, our committee clerk Santerre McKenna, and then the planning clerk Debbie Wood. And we proposed 3 names so that there was some potential movement and opportunity for any potential conflict that may exist or relationships that may exist in the community, that we could move the files around to better disperse things and to provide great accountability. And then the hearing officer is a third-party contract. We've proposed currently a solicitor from one of our municipal solicitors' offices, Rachel Jansen. She agreed to put her name forward for council's consideration. We are actively looking for a second hearing officer, so that we can have some disparity, so that if there were a conflict that existed, that we have a second party to go to. We don't anticipate needing to appoint one at this moment, but we are actively looking, and we'll bring that forward probably in the new year for council's consideration as well. But for now, we have one name forward as a hearing officer for consideration.
Okay, thank you. And my second question is related to front and side yard parking. I guess I'm not sure the reason behind this bylaw, but there seems to be a fair number of people who have completely paved or hardscaped their front and side yards for parking, and they don't have a blade of grass in sight. So I'm just not sure why some people can do it and some can't.
Through you, Madam Mayor. Excuse me. These matters for parking on, I guess, people's side yards, rear yards, front yards, are sometimes zoning matters as well. They would have to make sure they comply with the zoning. And sometimes they do and sometimes they don't, unfortunately. And if we get a complaint, we investigate that, of course. And we would have communication with the planning department. If we receive a complaint of somebody parking on the grass, on the side yard, with this new parking bylaw, with those provisions, the officer could attend and help educate the owner that you cannot park in that spot if it's not a proper parking location. An individual can request the municipality to make sure they're in compliant with the bylaw or the zoning bylaw to make sure that they can widen their driveway. There are certain provisions under the zoning bylaw that would allow them to do that. In some cases, individuals are not compliant, and if we receive a complaint, we would investigate that. This mechanism within the parking bylaw, it provides bylaw services officers the option to attend, inspect, educate, give warnings, and if required, issue a penalty notice under the AMP bylaw to get compliance if they're not compliant. Because we do get complaints, and that is common. It's to protect the care of the boulevard. It's to, in most cases, and we've had several complaints in the past where certain areas, certain properties, the boulevard has been destroyed, unfortunately, because of the vehicles parking, driving over, and that is why these type of bylaws are enacted.
Okay, thank you. So if someone actually paves or hardscapes their entire front lawn and side of their houses, then they are technically parking spots?
Through you, Madam Mayor, not necessarily. Yes, it depends on, we might not be compliant with the zoning bylaw. And that is something that they should seek to communicate with the planning department to determine if they can extend their driveway. And the planning department receive those requests regularly, and they do assist to determine if they're compliant, if they can, or if they can't, what mechanisms they can apply for as a variance application, something of that sort, to become compliant or to widen their driveway.
Okay, I'm just going to, someone else wanted to weigh in there? Is it, oh, Director Martin, thank you.
I just wanted to add, Madam Mayor, is that it's always great to consult with the planning division as well, especially in our newer subdivisions. There are stormwater features that may be located within front and side yards of properties that property owners might not necessarily be aware of. So when we do have individuals who alter their front or side yards to create additional parking spaces, they may in fact be interfering with stormwater features or drainage features that they're legally obligated to maintain as part of the subdivision agreement registered against their property. So the bylaws are one way of also trying to protect those features, especially in our newer developments, from being damaged by homeowners.
Okay, Deputy Mayor, while we're
Yeah.
there, and then I'll go to Council. I haven't not forgotten.
Yeah.
We returned to this issue, so let's just try to finish the
Yeah,
conversation.
thank you, Madam Mayor. This is relevant to the current discussion. So my understanding is that if this one penalty was removed, parking on front and side lots, zoning would still be in effect. They would still have to comply with zoning.
Through you, Madam Mayor, if the provision was not included in the AMPS bylaw, there'd be no mechanism for compliance other than an official process through the Planning Act, the comprehensive zoning bylaw, which can be quite lengthy to get compliance and often requires the hiring of a solicitor, municipal solicitor, to prosecute those files.
Okay, I'm going to recognize Councillor Wilson.
Through you, Mayor Peckford, to Mr. Barabo. Earlier in the presentation, you talked about automated speed enforcement. Does that mean we are going to have that in North Grenville and there's going to be cameras all over the place?
Through you, Madam Mayor, no, that's not correct. This is included as many municipalities are looking at automated speed enforcement for many different reasons. It could be red light cameras, speed enforcement, and those are the main two. And many municipalities are moving those automated speed enforcement provisions into AMPS other than instead of the provincial offenses court for the process of recovery of appeals, and that is why it's included
Okay, thank you.
for future implementation if wanted by
You
council.
had me a little excited because I thought here we were going to get the automated speed enforcement and that would cut down on all the complaints.
Right, but to that end, I do believe that Ms. Preston and Mr. Barabo and Ms. Dunlop are working to bring consideration of an automated speed enforcement bylaw to our two community safety zones, certainly, in fairly short order. So who would like to speak to that right now? Is it Ms. Preston or Ms. Dunlop?
Thank you, Your Worship. So yes, we have been, the Public Works Department and now the Bylaw Department are looking at having the automated speed enforcement in Concession Road, which is the community safety zone that exists with certain traffic calming measures, not always adequate. So that this gives us the opening, the leeway towards the enforcement. But of course, there's additional requirements for placement and bylaw enforcement that will have to come back, and that will be included in part of the 2025 budget deliberations.
So I had understood that actually there were two community safety zones, one on Clothier and one on Concession, that would be most likely considered, not just one. We know we have a very busy and congested Clothier Street area where I think equal amount of concern has been expressed. So are we only looking at one right now?
We are working in conjunction with the United Counties of Leeds and Grenville for that other location, as it is a county road.
Okay. And in terms of a timing perspective, my understanding is we potentially were looking at a spring implementation of automated speed enforcement?
Yes, Your Worship, that is correct. There is a certain value that is left over in the Public Works Department with the creation or the hopeful passing of this process will give us one step closer, as well as the world has changed in regards to automated speed enforcement. There are more companies doing it. There's more municipalities performing the function. So it makes it easier for municipalities as a size like ours to be able to get our hands on and have enforceable pieces of equipment at a much more reasonable price.
Great, thank you. Okay, so Mr. Barabo, back to you in terms of, Council Collins, is there anything else that you want to ask questions of right now before Mr. Barabo continues? Feel free.
Yeah, and I apologize through you, Madam Mayor, to Director Barabo or Manager Barabo. I apologize for interrupting your presentation. You may have this answer for me later on. Getting a hearing, is that dependent on actually paying the fine? Is that a question of,
Through you, Madam Mayor. There is no fees to request a hearing or a screening first, and then to a hearing officer. That you don't have to pay the fine. It's actually, if you pay the fine, if the individual pays the fine, they pretty much affirm that they're guilty. So it would be, the website will have all those details, and it will guide the individual through the process. And so, yes, they would not pay it if they decide to bring the matter to a screening officer.
And is there a stipulated length of time between issuance of a fine, you meet with the screening officer, and you're still not satisfied, or the screening officer sort of stands by and doesn't concede anything, if you will? How long would it take you to hear from a hearing officer or to be in front of a hearing officer?
To you, Madam Mayor, the individual debating or wanting to bring that matter to a hearing officer has 30 days to apply or request that hearing. And then within a 30-day period, they would have to receive 30 days minimum notice of a hearing time period or date to meet, so they can plan ahead. And so there'd be plenty of time for everyone involved to plan it.
And finally, in terms of payment, I saw reference to online, I saw reference to checks. Can you help me understand what forms of payment people would be able to access to pay their fine?
To you, Madam Mayor, currently our system is online. We'd be accepting credit cards. If an individual attends in person, they can pay by debit. Okay. They can pay by cash. If they want to pay by mail, they can send a check or a money order.
Okay, great. Councillor Sullivan.
Thank you, Madam Mayor, through you to Mr. Barabo. So if someone chose to pay by credit card, on the phone. Is there an additional fee to use a credit card?
Through you, Madam Mayor, currently, under current system, there is an additional fee, and that I believe it would still incorporate, we're changing to a new system in regards to this AMP system if approved, and those are all things that we would have to consider, but normally the fee is passed on to the accused or the individual who received a penalty notice.
Is this normal for most municipalities, that you have a fee to pay things by credit card, especially if you don't have the option of an e-transfer?
Through you, Madam Mayor, my experience, my research has shown, yes, that is quite common, but it's up to the municipality. If we want to absorb that fee, that is an option.
Okay, well, I would suggest that we should absorb that fee until such time as we can take e-transfers.
Okay, excellent. So we'll carry on with the presentation. Do I see any other hands? Are we good? Okay. So we'll carry on, but we may interrupt you again, but I think that'll save a lot of Q&A at the end, so thank you.
Of course, thank you, Madam Mayor.
Okay.
We were discussing the policies, and as previously mentioned, there's 4 policies that are required by legislation, and a 5th one that we're proposing on undue hardship. In regards to the policy for financial management, it outlines that bylaw services officers, screening and hearing officers are not permitted to accept any payments in respect of a penalty notice, that municipal staff shall follow corporate or departmental payment handling procedures. It specifies that credit card information cannot be kept on file. In regards to the public complaints policy, public complaints relating to AMPS, to the system in general, are to be investigated by the manager of bylaw services. The policy provides a framework for staff to follow. The policy for undue hardship defines what is undue hardship, which means financial hardship or other extenuating circumstances based on compassionate grounds. The policy applies to screening and hearing officers, and it's in circumstances where a person claims undue hardship. The policy helps guide the screening or hearing officer when deciding to affirm, reduce, cancel, or provide more time to pay a penalty notice. Automated speed enforcement, as previously discussed, the AMPS bylaw includes provisions for the implementation of ASC in the framework to implement an ASC program. An ASC is pretty much a ticket, but in the bylaw itself, it's called a penalty order. Schedule C of the bylaw is purposely left blank. If the municipality implements an ASC program, the schedule will be updated to include the appropriate penalty amounts as determined by the province. These amounts are legislated. We don't have an option to make any amendments. The officers and agents bylaw, as previously mentioned, will be updated for the screening officers, which have been chosen to be Debbie Wood, Mary Remig, and Santerre McKenna. The hearing officers is Rachel Jansen, a local lawyer from Jansen Law.
I'm curious about this because, and maybe Ms. Martin, this is a question you can answer. So we have the ultimate authority for AMPS, like the day-to-day practice of implementing AMPS is under you, Mr. Baribeau? Like
To you, Madam Mayor, a lot of the daily activities is the responsibility manager of bylaw services, but ultimately it goes to the Director of Planning and Development and to the CIO of the municipality.
Okay, so the bylaw officers work, of course, with you as the manager, and of course you report to Ms. Martin, correct? So at the same time, you're going to have Ms. Wood, who also reports to Ms. Martin, as one of the screening officers. So I'm just curious, does that not create a conflict where you have 2 individuals, right? So you would have, bylaw officers reporting through you, Mr. Baribeau, to Ms. Martin, issuing a potential penalty under AMPS. Then you would have Ms. Wood also reporting to Ms. Martin, potentially screening, right, a file where a resident might say, look, I feel like this was done in error, right? So maybe Ms. Martin or Ms. Preston, you can speak to whether or not the reporting structure potentially creates some complexity. Because I would find, I know that Ms. Wood has a great degree of knowledge about planning, and I expect that's partly why, planning and building, and I expect that's partly why she's been identified, but I find the reporting structure a little bit unusual. where you're reporting to the same person who might in fact end up contradicting an action of a bylaw officer if, of course, she believed that the bylaw officer hadn't issued or had issued the fine in error.
Through you, Madam Mayor, and perhaps Director Martin can relay any information that I don't. We had selected Ms. Wood for the screening officer because of her involvement and knowledge with regards to Committee of Adjustment. And Ms. Wood has also acted previously as a elections officer for the municipality as well. So she's undergone quite a significant amount of legislation or legislative training. It also provides the opportunity for additional knowledge and learning for Ms. Wood. But we also built in the systems that if Ms. Wood felt that she couldn't adjudicate something herself, that we could pass it along to other staff members and we can move files around. With regards to reporting, I hear your concern with regards to the fact that she and Manager Baribeau both report to Director Martin. In this case, I think that the policy set out very explicit situations and procedures to follow for the screening officer. So I'm not sure if we would be concerned about the potential conflict. However, if we felt that there was, we could always entertain it at a later time or at this time to remove Ms. Wood from the screening officer provision. However, Ms. Wood is not necessarily directly involved with the bylaw division within planning and development. My understanding is that she's exclusively within planning, as the building department has a clerk, and while bylaw doesn't, they handle their own administration or their administrative tasks. So I'm not sure if there would necessarily be a conflict in that regard, but that the policy could speak to it. And if Ms. Wood felt as if she were in a procurement or a procured position, that she could hand it off to another screening officer as well. And if she felt that it was becoming a matter of conflict for herself within the department, then she could also approach ourselves or Director Martin to have herself removed as well.
I think more for us, it's perception, right? It's not, right, they necessarily, any comment on any person who would serve in this position. So let me be very clear, Ms. Wood has so much knowledge and, to your point, insight. I think it's just how do we create a structure where there's confidence, right, that individuals are able to act objectively. Of course, I understand that every screening officer would endeavor to do that, so please don't misunderstand. But this is a very different and new system for the municipality of North Grenville, so I'm just sort of thinking through how people might experience their interaction with a screening officer who's embedded in our planning department, when perhaps some of the, obviously some of the fines issued, right, also happen to be, at the end of the day, sort of, obviously reporting to the same director. So Ms. Martin, and again, this is not about individuals, it's just about structure and perception. So Ms. Martin.
I just maybe wanted to add about the function and the role that the planning clerk plays within our division. Ultimately, any matter when it comes to interpretation of bylaws or seeking that planning advice wouldn't go through the planning clerk per se. It would come directly either to myself or to the deputy director, who have more of an involvement in being able to provide that professional opinion. And ultimately, that's why there's also an external hearing officer. So should there be concerns that there is a conflict, because I think at any point you could say there is a conflict on any part of staff, because we are an office that does work closely together. It doesn't matter which department you're in. We do have some crossover every once in a while, but that is the intent of having that hearing officer that is external to the municipality. Should someone feel like through that due process that there is a level of unfairness, they could take it up to that level.
Yeah, again, I was more asking from a perception perspective, but thank you, very helpful to know. Obviously, anybody can kind of activate that hearing officer for any reason, right? So even if they have a very robust discussion with the screening officer, the basis for them to activate the hearing officer can be at the discretion of the person who received the fine. Is that right?
That's correct. Madam Mayor, if I may, there's no additional cost as well. And so it's part of the process. If they are not, they don't agree with this decision of a screening officer, there's no additional cost to appeal it to the hearing officer, which is a third party.
For sure. Okay. we'll let you carry on. I apologize, Councillor Strachan.
Sorry, Madam Mayor, I just, something came to mind. There's no additional cost to the person who's received the fine or the ticket. Is there an additional cost to the municipality every time the hearing officer is, their services are needed?
Through you, Madam Mayor, yes, there would be. There is a cost.
Thank you.
All right, carry on.
Are there any questions?
Oh, this is the end. Okay, excellent. Okay. With that in mind, colleagues, is there anything else that you wish to address with Mr. Barbeau? If we could go to the beginning part of the slide. Are you able to go back to the first? Are you looking for a different slide, Councillor Strachan? Okay. Just the beginning couple of slides. This was it. So designated bylaws to be included in AMPS. So again, we've had a little bit of a discussion on the parking bylaw, which includes those provisions around front, side, rear. Is it all three or is it just two?
To you, Madam Mayor, the rear is not included,
Okay.
just the front and side.
Okay. Could you help me understand the care of roads?
The Care of Roads bylaw is all the bylaws before you are new bylaws, new numbers. The majority of them, except for the yard maintenance and the smoking and vaping bylaw, have little changes, but the yard and maintenance and smoking bylaws are completely new ones, as outlined in the report to council. The Care of Roads bylaw deals with mostly the maintenance, the blocking of roadways, and if they, on the report to council, the Care of Roads bylaw, the main changes to it was an exemption provision was added to permit a person who has received written authorization from the Public Works Department to push snow on or across a highway. That's the only difference in the bylaw other than the AMPS provisions being included.
And why would it have changed to include that language?
To you, Madam Mayor, in the past, we've had requests for an exemption, and we have had discussions here between staff and the Public Works Department to have an inclusion, where they may have a need for having to push it onto another property they own, or maybe there's a better way of removing snow, and this mechanism provides that option for Public Works to issue a letter saying that, yes, it's permitted.
Gotcha. Okay, thank you. The smoking and vaping, that's a newer one? Did I hear you correctly?
Yes, that's correct. The smoking and vaping bylaw are completely new bylaws. It was a bylaw borrowed from the City of Ottawa, and is supported by our local inspector, our health inspector, who would also have the authority to enforce the bylaw. Police, bylaw officers, and the Smoke-Free Ontario Act inspector. A lot of the provisions, now the newer provisions also include the cannabis and also vaping, which our previous bylaw did not have those provisions. It was out of date. It was bringing it into the new, because of cannabis now being legal, and you can smoke that publicly, but in certain locations you cannot. Our previous bylaw did not have mechanisms to address it, and now it does, and then the vaping as well.
So it's what is smoked and how it's smoked, right? Because the
Correct.
vaping is a new methodology, if you will. And so are our smoking and vaping bylaws identical? So smoking and vaping would be treated exactly the same way?
In the bylaw, they are correct.
Okay. And that is a best practice across Ontario, I presume?
I can't speak to you, Madam Mayor. I can't speak to all the municipalities, but the Smoke-Free Ontario Act is consistent with our bylaw. Or our bylaw is consistent with the Smoke-Free Ontario Act.
Okay. So we have a provincial piece of legislation.
Which is more in depth, sorry, Madam Mayor, which is more in depth for Ontario smoke-free inspectors.
Okay.
They have additional powers, licensing, but the provisions in regards to distances from schools, from municipal property, is consistent.
Okay, sounds good. Other questions, colleagues, in terms of the list? All right, Deputy Mayor, go ahead.
Yeah, two questions. First, I understand that this list is not comprehensive, but these are new bylaws or current bylaws that are being updated, but the AMPS policy will affect many more bylaws. Is that right?
Through you, Madam Mayor, currently brought before you here, we have the 10 bylaws that we wish to include as designated bylaws. In the future, with time, resources, other bylaws will be brought forward as well to include those provisions to enforce and through the AMPS instead of the Provincial Offences Court.
Great. And through you, Madam Mayor, to Manager Baribeau. Yard maintenance is a new bylaw. We currently have property standards. Why the distinction? Why wouldn't yard maintenance be included under property standards?
Well, through you, Madam Mayor, the property standards bylaw, most of the power comes from the building code, while the yard maintenance bylaw, the authorities come from the municipal act. The property standards bylaw mostly deals with structures in general. It can include the cleanliness, garbage, but that is why in-depth yard maintenance that we have today, the bylaw being proposed, can remove some of the burden on the property standards side of things and include it more on the municipal act. It's a more of a streamlined process. Both of them would have the provisions for AMPS. It just provides, it separates the two, one being more for structures, one being more for the cleanliness of yards, the maintenance of properties in general.
I didn't drill down deeply, but is there a copy of the current or the proposed yard maintenance bylaw in the package?
The proposed one, yes, correct, it's in the package.
It's in the package.
Yes. Our existing one is quite dated, and it is my opinion that it should be repealed and enacted with this new bylaw.
Okay, thank you.
Other comments or thoughts? Yes, Councillor Sullivan.
Thank you, through you to Mr. Baribeau. On the yard policy, vegetative growth and lawn, et cetera, does this policy apply to municipal property?
Through you, Madam Mayor, I'd have to specifically double check if it includes municipal property. Usually the municipal properties are excluded from our bylaws. We have exemptions. I could take the moment to double check in the bylaw itself if you would like, but most bylaws we have the exemption. The municipality would have an exemption.
Okay, so a vacant lot then that has vegetative growth that's like 2 feet deep, 2 feet high, it's a private property, but it's vacant and just left to go to seed with weeds, et cetera, that would fall under this, but not a piece of municipal property that was in the same condition. Because people will say that, you've got a lot right here that's left.
Through you, Madam Mayor, if we do receive those complaints, we do forward them on to the proper department and share that information with them to do maybe perhaps more maintenance.
Okay, thank you.
Okay. The one other question I had was the sewer use bylaw. That's an existing bylaw?
To you, Madam Mayor, that's correct. It's the sewer use bylaw is an existing. There have been no changes other than the formatting and the provisions for AMPS and also the inclusion of the wordings and set fines.
And Councillor Strachian.
Thank you, Madam Mayor, through you to Mr. Baribeau. So returning back to lawns and vegetative growth. So I think you're aware that the Environmental Action Advisory Committee has put forward some recommendations when it comes to lawns and front lawns per se and what they can look like and some opportunity for potentially some changes. So I just have I guess a question to you. Going forward with this yard maintenance bylaw, I think will trigger further discussion about where there may be parts in there that committee in particular would feel would be restrictive, especially when it comes to the type of landscape you have in the front yard. Lawns are one thing. No mow may is definitely something that comes to mind. Natural growth gardens and the like, and some of those would and could easily exceed the height limitations that you have. So I think I'm just sort of putting that out there, that I think that will trigger that, I know that it will trigger that conversation. And then in paragraph 8 under vegetative growth and lawn, there's statement that says an owner shall ensure that vegetative growth or lawn on their land do not create a public health or safety hazard. That's not a problem, or a nuisance. And I have a challenge with the words nuisance because I think that sounds very subjective as to what could be considered nuisance. I don't see it defined in this bylaw, so perhaps I'm missing it elsewhere, but perhaps if you could clarify what would qualify as a nuisance. I use an example. I'm not in an area where this would apply to, but if you have asparagus growing in your lawn, it gets pretty unruly very quickly, and you don't trim it back until much later in the season. It can very easily exceed 3 feet tall. It's a garden. It provides food. It's an ongoing thing. But if there's other vegetation that I could think of that would fall into that category, if somebody were to say, I don't like the look of it, is that considered a nuisance? Where are the lines drawn for that? So I think you understand where I'm going with some of this. So perhaps if you have some comments about any of that.
Through you, Madam Mayor, this bylaw was adopted or shared from the London City, where they had received recommendations from the community, just like our community, for more vegetative growth in the lawns. And this is towards achieving that. It also lists the prohibited plants in the back, which limits what they can plant. And most of them are noxious weeds as per the Weed Control Act. Yes, I understand your concern about the nuisance. I interpret it more on where it's interfering with somebody's maintenance of their property, perhaps, or causing a hazard. I know hazards listed, but something more along those lines, not just a nuisance based on somebody's recommendation or their opinion on how something looks.
So we let our dandelions grow wild on our lawn. I'm sure some neighbors don't appreciate that because it goes to seed and it can spread. Would that be something that somebody could say, hey, I don't appreciate this because I'm spraying my lawn, I'm trying to get it weed free, and my neighbor has dandelions growing here and now they're just going to spread to our lawn. Would that be something that could be considered a nuisance?
Through you, Madam Mayor, that's a good interpretation, something that we can probably define at a future time with providing a definition specifically for nuisance in the bylaw.
I'd appreciate that. It would be worthy of consideration, I think. Thank you.
Yes, Deputy Mayor, go ahead.
Thank you, Madam Mayor, and maybe you can help me decide who to direct this question to. But just following up on Councillor Strakian's comments on this one bylaw about yard maintenance, is this an instance where we could pull that particular bylaw and ask the Environmental Action Committee to comment on it and bring it, those comments come back to council? Is this an instance where we can direct an advisory committee to do some work for us? That's a question to you, Madam Mayor, I guess. Or you can tell me who to direct it to.
Well, I certainly think it's within the purview of an advisory committee to provide advice that we might seek, certainly through deliberations of the committee. So I don't see that there is necessarily a problem with that, but I'll look to Ms. Preston and then Councillor Strakian. Go ahead.
Absolutely, through you, Madam Mayor. We could pull this bylaw from consideration for this evening and provide direction to the advisory committee to perhaps provide a definition of nuisance or other recommendations with regards to the bylaw. It would just be at council's notice that it would not be enforceable under AMPS as per the remaining bylaws in consideration for this evening. But if council is comfortable with that, we could do that and direct them perhaps to even come back in spring of 2025 with regards to their comments on the bylaw for then inclusion in AMPS.
Great. We're a very rural community, and I feel that this yard maintenance bylaw, it may not be in the spirit of our community, actually. So I feel like for maybe some of our better established subdivisions, sure, maybe there's a shared consensus around a particular aesthetic, but I too have reservations about including this at the present time because I think there is a lack of definition and there's a lot of subjectivity. So council colleagues, obviously it's our decision about whether or not we include it, but I do think that perhaps some more thinking should be done before we proceed. I'll recognize Councillor Strakian.
Yeah, if I may, Madam Mayor, I think that there are parts here that are I think are more obvious when it comes to refuse or any waste or, garbage that's generally unsightly and that kind of thing. And when there poses a public safety or health concern. But then there are other parts in here that I think are more nuanced. So because they're together, I'm not sure we would want, that I think going forward with the whole thing as it stands right now, it could be placed, at least as far as the Environmental Action Advisory Committee goes, I think it could be placed as a priority for review because they've already given some consideration to some of this and they would be able to return relatively quickly to council with some points for consideration.
Okay. So it looks like Ms. Preston is just drafting some language in regards to yard maintenance. Colleagues, the other thing that was brought to our attention is that we could include a grace period for the provision or the prohibition on front and side, what's the language again? Front and side yard parking. Does Ms. Dunlop or Deputy Mayor wish to flag something? All right. It's really, if you're talking but you're not into the mic, it's not being captured publicly. So go ahead.
I apologize. Yes, I think if we're looking to adapt or modify the side and front yard lot parking, that we should give some consideration to stormwater management drainage. We should make sure that that's part of the power of the bylaw to prohibit front or side yard parking if it interferes with stormwater management.
Is the bylaw as currently written contemplating that or no? Ms. Dunlop?
Thank you, Your Worship. The bylaw, which currently is in effect, doesn't permit such activities, such as pulling your vehicle where we'd normally put a snowbank or things of that nature. So if we are going to give grace periods for consideration, it should also be considered that if there is an impedance on public operations or stormwater management, that would, we'd have other enforcement tools rather than a grace period, a warning system versus an outright allowance of the function.
So maybe I can ask it this way. So if you've currently been parking on your front yard or your side yard, and you, through this bylaw, are prohibited from doing so, wouldn't it have already been the case that if you were interfering with a municipal operation, that would have been brought to our attention? I mean, if it's interfering with a municipal operation, it wouldn't have gone unnoticed. Am I mistaken in that?
I wouldn't necessarily say, Madam Mayor, 100% of the time, that there are instances where even we have asked people not to do certain things because it's impeded municipal operations, because they've been doing that way for so many years. They don't want to change. So I think that we have to work with them and look at alternatives.
How would you propose that we allow people to adjust to the new prohibitions, which may take engaging in a committee of adjustment meeting through some sort of zoning, a minor zoning accommodation? I guess I'm struggling with immediate enforcement and limited grace period. I'm not optimistic that people can be in compliance if they require a minor zoning or variance in order to proceed. I feel that it's going to take a lot of time. So are they fined and then fined again and fined again? Like, how does the scenario work where someone can't get into compliance quickly? What happens then? So maybe, Mr. Baribeau, you can speak to that.
Thank you, Madam Mayor. Currently, someone or individual parking on the boulevard, for example, is in violation of the
You
current.
say boulevard, so help me understand.
So
'cause
the
You mean
property,
road?
municipal property from the road up to their property line, the boulevard.
Oh, that is defined as a boulevard.
Well,
I
that meets
asked,
the definition of boulevard. Boulevard can include several different areas as well, but in the bylaw, so that portion between the road and their property line is considered a boulevard. And as per the Care of Roads bylaw, they'd be already in violation. And also in violation of the zoning, perhaps, if they don't have that as an approved or, as a designated spot for parking on their own driveway. With the proposed provisions, would provide an enforcement tool. And when I say that is it allows the municipality to go on there, because the Care of Roads bylaw is not issued to a vehicle, it's issued to an individual. And this way, an officer, for example, if you get repetitive individuals who are not compliant, and I suggest that municipal staff or bylaw staff would go and educate these individuals with letters, warnings, and we are going to work with them. It's not to issue fines on somebody's property and just walk away. It's to provide that. But if individuals who do not want to comply, who we do encounter them sometimes, a ticket or a penalty notice could be issued at that time and left on the vehicle for repetitive violations.
Sure, and so I asked the question about boulevard because we talk about the County Road 43 Boulevard. So when you use the word boulevard, I think you're invoking a different definition that I'm not familiar with, so I appreciate the explanation. But just going back, if it takes someone, say it takes someone 3 months to 6 months to go through a committee of adjustment process, retain the right experts, make an application, I'm wondering, in that instance, where does the discretion lie to say find someone multiple times because it's taken them 3 to 5 months to undertake the right effort to either legitimate what they've been doing, I assume. But if we're prohibiting front and side yard parking, it begs the question of where would they park? How do they, apart from going through a committee of adjustment, minor variance, if they have no alternative, then clearly that will take some maneuvering, right, on the part of the property owner. So I guess I'm trying to figure out, they may have to sell a car, they may not be able to continue doing what they've been doing for a long time. So how do we account for that period of accommodating to a new prohibition, which as I understand it, we haven't had up to now?
If I may, Madam Mayor, the prohibition was always there under the Care Roads bylaw. It's just, it was very difficult to enforce.
I see.
And now this provides an enforcement provision.
Right.
To leave a penalty notice on the vehicle.
Right.
And in most cases, bylaw services would not issue a ticket without speaking to someone. And the only reason for under parking violations normally is because you don't know who the driver is and you leave a penalty notice on a vehicle and you walk away as a bylaw officer. But in these cases, the officers will know where they are. They'll know that the resident, they can do a research, identify the owner, and communicate with them, issue a letter, attend their door and knock, and have those conversations. And bylaw services officers deal on a daily basis where individuals are working towards compliance and they understand that, and they wouldn't be issuing notices in those cases if that person's working towards compliance. It's when they're no longer working towards compliance or refuse to go towards compliance. So that those penalty notices could be issued at that time.
And maybe just one more question. I'm just getting very practical here because I'm trying to think through the implications, right? So you have a teenager in the house who starts to drive. Typically, it was a 2-car family. Now it's a 3-car family, right? They live in an area where there's no capacity to extend a driveway or legitimate it through our current zoning provisions. So that family trying to accommodate a teenage driver or a young adult driver has to rethink how they're going to accommodate, say, the 3rd car. This is theoretical. I guess I struggle with the fact that they will need time to find an alternative. I don't know if it's a new property. I don't know if it's street parking or negotiating with a neighbor. So these are the areas where I think as we intensify in more urban areas, this may become a real challenge for certain people to be in compliance in the way that we might expect otherwise. Do you have any thoughts?
If I may, Madam Mayor. Thank you, Madam Mayor. The new parking bylaw provides provisions now where individuals can park on the roadway during the winter, where that never existed. So that creates a lot of extra parking for individuals in that type of circumstance. The only time they would have to remove it is during a winter storm event, which lately hasn't been too many a year, but there are certain occasions. So they would have to make arrangements for those vehicles to be removed off the roadway at those times only. So now the roadway, as long as lawfully parked, not where there's a sign that says you can't park, provides those extra parking spaces during the winter months overnight.
Good, that's a great reminder. And so help me understand how that interacts with the prohibition to park on a boulevard. If you're doing on-street parking, where does the definition of a boulevard kick in?
So on-street parking would not affect, in most cases, the boulevard.
Okay.
The boulevard is mostly like the curb, and they're driving, in many cases, the individuals have cut the curb or driving over the curb, and they're driving onto their property and damaging the boulevard, damaging their own property in some cases. And that's where this bylaw would help with for
And
compliance.
so in your mind, that is quite separate and apart from on-street parking, the sort of the practice of on-street parking?
Sorry, can you repeat that question?
So if you're parking on the road, but you're not affecting the boulevard, then you're good to go.
Correct. If you're parking on the road in a proper
Yes.
spot, that you're not
Right.
infringing on any other provisions of the parking bylaw, that is permitted. Correct.
And the consideration for the boulevard would kick in when exactly? When you're parking in front of your own property?
Any boulevard. in
Any
theory.
boulevard.
You can be attending your friend's house and driving up on their boulevard, for example, and damaging municipal property. The care of roads bylaw technically is currently in place, and this parking bylaw would also, or the provision available would help address that. But again, compliance is the main goal of bylaw services, and communication or conversations would be had with property owners prior
Okay.
to any enforcement.
Okay, great. Okay, thank you. I think we've belabored that, or I have, thank you. Councillor Sullivan.
Thank you, Madam Mayor, through you to Mr. Barabo. So in a case where there is a laneway, the curb has been cut for the laneway, and that's fine. And people come into their laneway, and then they have paved the entire front lawn and the side of the house. And they park a boat or a recreation vehicle on the side or in the front. So they're not on the boulevard, they haven't damaged the curb, they are just paved the whole front yard and parked their boat and RVs on does this bylaw apply to RVs and boats that are parked there?
Through you, Madam Mayor, if the driveway was extended contrary to the comprehensive zoning bylaw, then this provision is there to help with the enforcement of the comprehensive zoning bylaw, and it's to help with the enforcement at that point, correct. These provisions provides the power for the municipal officers to attend, go on the property, and complete those inspections, and to issue tickets if required, but of course to have those conversations prior to. So the main thing here is that if they're in violation of the comprehensive zoning bylaw, this is helpful for an enforcement tool.
Okay, are there questions about any of the other proposed bylaws to be included in AMPS? So we're looking at exempting the yard maintenance bylaws, I think, part of the consideration this evening. In terms of a grace period for enforcement of our, I guess, aspects of our parking bylaw, can you exempt certain periods, or are we considering the parking lot bylaw in full?
Through you, Madam Mayor. We have a proposed amendment following the conversation that we had earlier for a 4-month grace transitional period for front and side yard parking, as well as direction to the bylaw staff with regards to the overnight parking provisions that are currently prohibited in the existing parking bylaw that will no longer be prohibitions in the new parking bylaw that comes into effect. So we also have some direction to bylaw staff with regards to that, if that's council's wish this evening.
Okay, great. Thank you. Councillor Strachan.
Thank you, Madam Mayor. To the clerk, I'm wondering if 4 months is the right time, because 4 months is effectively winter. And I think you would see differences between winter versus clear weather where there's no snow or anything like that. So not to make this go on indefinitely, but because of the time of year that we're at right now, 4 months may not make the most sense, because that effectively brings us to February, March. But perhaps a little bit longer to go into the nicer, clear weather, clear roads, no more snowbanks, that kind of thing, to allow for a full coverage, I guess, of those different conditions would be reasonable. So maybe 6 months is a better number to allow for that.
Absolutely. Through you, Madam Mayor, I misspoke. It was 4 months from the date of passing of January 2nd, so that was my error. I apologize, Councillor Strachan.
Well, then we're on the same page. Thank you.
Okay, so with that, colleagues, is there anything else we wish to bring to attention, to our own attention or staff's attention before we proceed with consideration of recommendations? I see Deputy Mayor's hand.
Thank you. Just to follow up through you, Madam Mayor, to the clerk. Chloe, the direction is also to direct the Environmental Action Committee to review, right? Thanks.
Yes, I have some proposed language to direct the Environmental Action Committee to provide comment on the draft Clean Yards Bylaw 105-24 and specifically comment on the definition of nuisance for consideration. I'm not sure if that's the motion council wishes to enter into, but I'm happy to amend it as directed.
Okay, so with that, should we go to consideration of the recommendations from staff colleagues? Oh, yep. I would prefer to take 2 minutes so that we tackle this in the right way. So if we could just take 2 minutes, then that will help me ensure I'm proceeding in the right fashion. Thank you. Okay, we're coming back. Council colleagues, we are live. Thank you. We are reconvening our special council meeting. We've had a fairly robust discussion on AMPS, and Ms. Preston has some proposed recommendations for our consideration. So Ms. Preston, over to you. So we'll deal with the 3 recommendations separately with a mover and a seconder? Okay, let's do that. All right, so the first recommendation.
Okay.
Ms. Preston is going to read it.
That council pass and enact bylaw number 10724, a bylaw to implement an administrative monetary penalty system in North Grenville, and that council adopt and enact bylaw 10624 to establish policies in relation to the administrative monetary penalty system, and that council approve and enact bylaw 5924 as amended, and that council pass and enact bylaws 9724, 9824, 9924, 10024, 10124, 10224, 10324, and 10424. That will be the first motion, which I will note excludes the clean yards bylaw, which has a subsequent motion for consideration at a later time. Do you want to do those separate?
Potentially, yes. Just deferring to council colleagues, are we satisfied with the motion or the recommendations that's just been read? Would we like to get a mover and seconder for that first motion? Yes, Deputy Mayor.
Before I vote on this motion, could the other 2 motions be articulated so I know, I can be assured that nothing's been left off from our consideration?
So the first motion is obviously around the adoption and enactment of the bylaws as it pertains to the list that was presented to us, except for, as Ms. Preston noted, the yard maintenance bylaw. The other bylaws are in regards to the following, so maybe we can read them all and consider them as one motion. And that council directs bylaw staff to not enforce the overnight parking prohibitions of the current parking bylaw unless a weather event is occurring until January 2nd, 2025, when the new parking bylaw comes into force and effect. That's one caveat. That council direct bylaw staff to implement a 6-month grace/transitional period for front and side yard parking prohibitions within the new parking bylaw commencing January 2nd, 2025, to provide information to residents on the new parking provisions. And finally, that council direct the Environmental Action Advisory Committee to provide comment on the draft Clean Yards bylaw, which is 10424, and specifically comment on a definition of nuisance for consideration. So those are all of the additional caveats in regards to the motion, which will obviously, as Ms. Preston read, adopt and enact bylaw number 107-24, with the exception of 105-24. It will enable the municipality to go forward.
In my mind, that captures everything we just discussed.
Any other comments, colleagues? Councillor Strachan? Yep.
Just to clarify, through you, Madam Mayor, to the clerk, the report that we received this evening also asked for the receipt of the report and directing staff regarding the implementation of AMPS and the monetary considerations. Is that another piece that you will be articulating after this?
Repeat your question, Councillor Strachan.
So I'm just looking at the report that we have regarding AMPS, and that there was the receipt of the options report, implementation of the AMPS with a few different options as to how to go about implementing that, as well as the anticipated consulting costs and so on. So that's in the recommendation section of the report that we received this evening as well, as part of our package.
So my understanding is that was the report from June when we first came.
So we do not need to do anything with any of that. Okay,
No,
I just
that was
wanted-
just provided for council.
Understood. Okay.
Comment or reiteration of what was previously presented to council. So
Fantastic.
I apologize for any confusion.
No, that's okay. That was my confusion. I appreciate the clarification. Thank you.
Okay, so with this in mind, the motion has been, I think, fully read. Ms. Preston? So we'll just maybe to make it clear once again, I'm looking for a mover and a seconder for the following. That council pass and enact bylaw numbers 107 to 24, a bylaw to implement an administrative monetary penalty system in North Grenville. The council adopt and enact bylaws number 106 24 to establish policies in relation to the administrative monetary penalty system. That council approve bylaw number 5924 as amended, and that council pass and enact bylaws 97 24, 98, 24, 99, 24, 100, 24, 101, 24, 102, 24, 103, 24, and 104, 24. And we note that 105, 24 has been removed from the list, and that's in regards to yard maintenance. The other motions that I've read would apply to this omnibus bill, if you will. So I'm looking for a mover and a seconder, please. Councillor Strachan? Deputy Mayor? Okay. So the motion is on the table. I believe we're all clear about the caveats in regards to parking prohibitions vis-a-vis weather events, a 6-month grace transitional period for front and side yard parking, and a direction to the Environmental Advisory Committee to provide comment on the yard maintenance bylaw. Anything else, council colleagues, in terms of consideration of this motion? Seeing none, I will call the question. All in favor, please? Great. That carries. Thank you. And with that, we are going to move to adjournment. There are no members of our community here. Of course, we have a couple of our bylaw officers. Thank you for being here. So we'll go to our confirmation bylaw, and that is, be it resolved that bylaw 10824 to confirm the proceedings of council at a special meeting held on November 18th be adopted and passed. Can I have a mover and a seconder for that? Councillor Wilson and Councillor Sullivan, thank you. I'll call the question. All in favor? And a motion to adjourn. This is at 5:50 p.m. that our special meeting of council adjourned at 5:50. Looking for a mover and a seconder. Councillor Strachan, Councillor Sullivan. Calling the question. All in favor? Okay, good. Thank you so much. We are